the approval of the minutes from the September 12, 2025 meeting. Ms. Harrison has emailed these to us ahead of time, but if you hadn't had a chance to look at them, go ahead and look at them now, and I'll entertain a motion at whatever point someone is ready.
Make a motion to approve the minutes for September 12th, 2025.
All right. Got a motion and a second. Any discussion, changes, questions? I see no one seeking recognition. So therefore, all in favor of approving the minutes of September 5, indicate by saying aye.
Aye.
All right, very good. Next item is to approve the minutes of the October 3rd, 2025 meeting. So same deal as entertain a motion as someone feels comfortable doing so. Got a motion from Commissioner Byrd. Is there a second?
Second.
Commissioner Janine Davis, seconds. Any questions, comments, suggestions?
Yeah, one comment. I know we have a.
If you'd turn your mic on, please.
I know we had an attachment that is with the actual minutes, right? Is that, okay. And I think that's the same with the other minutes where we did some of the interviews. I just want to make sure where whoever keeps that officially or whatever gets posted.
Please. We'll have everything scanned and attached.
Okay.
Yep.
All right, very good. Any other questions? Seeing none, all in favor of approving the minutes, say aye. Aye.
Aye.
Aye.
All opposed, say no. The minutes are approved. And then finally, the minutes of the October 13, 2025 meeting. Take a look at them if you haven't had a chance to do so already, and we'll entertain the appropriate motion as you're ready. Very good. Got a motion from Commissioner Byrd. Is there a second?
Second.
Seconded by Commissioner Dooley. Any questions? Comments?
One question I have, I can't remember.
Turn your mic on.
one question I have, I can't remember, it wasn't this meeting, we'd already done it. Which meeting did we change the certification date from December 8th to December 5th? I didn't see it in the other two. It must have been maybe the minutes before that. I'm just trying to remember when we did.
I think it was before we started the interview process, that previous meeting.
It would have been the one before September 12th.
Correct.
Right, because we already, all right, that's fine. I just want to make sure we hadn't missed that.
We can go back and check that to see.
Well, there was on the September 12th minutes, that was the motion that we moved to change the accounting board because we had to do that. But I think the meeting before, anyway, it's not that big a deal. I just want to make sure it was noted somewhere.
Okay. We'll check and see, and make sure that in the event we need to amend one of these minutes
Yeah.
to reflect
I'm pretty sure it was the one before.
that we did that.
Okay.
All right, I didn't call for a vote yet, have I? No, very good. Thank you for keeping me straight over here. All right, all those in favor of approving the minutes of October 13 indicate by saying aye.
Aye.
All opposed? Administrator Roberts, I'll turn over the next item to you relative to the certification of our most recent election results.
Commissioners, in your packet, number 5, you have not only the numbers from the actual election by precinct, but also included in there is a color document reflecting provisionals and the outcome of the research that we did. I'll give you a quick summary. We had 37% of our 235 provisional ballots were accepted. That number is higher than we've typically seen. Normally, it's been in the 20, 25 range. So we feel good that, we're making good progress on working with the voters to make sure they know what's important as far as provisional ballots go. Second, as far as the ones that were accepted, almost 60% of those were from voter registrations that we had on file that were incomplete. The state code allows the voter up until election day, on election day even, to correct whatever issue they have that was missing. They forgot to sign it, didn't give us their social security number, a variety of issues. So they can fix those, but on election day, they have to do it via a provisional ballot. So that was our biggest percentage. All others, the voter changed their mind. We sent them an absentee ballot, but they decided to vote on election day, didn't send us their absentee ballot back. Whichever ballot we get in first, that's the one that counts. So that's an example of how the provisional ballot process really works for the voter and gives them some flexibility. It also gives us flexibility in that anyone that shows up to vote, if we can't find them in our voter database, we're going to offer them a provisional ballot just in case there's some of these issues that come up that need to be fixed. We can fix them and their ballot would count. We feel like we do a good job making sure anybody that shows up that wants to vote can. As far as the ones that were rejected, 50% were because the individual was not registered at all. A lot of people think that it's like their driver's license. It travels with them whatever county they live in. They don't understand that you have to register by county. So, but one good thing with our provisional process, once they fill out the paperwork, they're now registered for the next election. So they'll be in good shape to vote in May. Another issue here, we had 10 individuals show up that we didn't have on the records because they had a felony conviction. that gives us an opportunity to go back and check with the state to make sure that's still the case. So a lot of this gives the voter kind of the benefit of the doubt until we can come back to the office. We've got essentially 2 or 3 days to check and make sure everything's good to go. Outside of that, I'm open to any questions that you might have about provisionals or the numbers from the election itself.
Let me just clarify one point, and I know you, I just don't want this to be in there blankly and not clarified, but you said that what we do, anybody who shows up to vote, we do what we can for them to vote, something to that effect. And of course, that means it could be a provisional ballot. Yeah, it all assumes that they're eligible otherwise, or perhaps could be eligible.
That's correct.
Yeah.
You know, if we don't have them on our electronic poll book, we're going to let them vote a provisional ballot because we don't know until we've done the research if they're eligible. It's after the fact that we determine their eligibility to actually vote. And if they are eligible, their provisional ballot will count. If not, like these people that were not registered or the felons, you know, their ballot will not count.
Yeah, thanks. I mean, I know everybody here knows that, and probably most people watching knows that, but I'm just a little obsessive compulsive about that. So, very good. So, thank you. Does anybody have any questions for Administrator Roberts?
Yeah.
Commissioner Byrd?
What is the state agency?
So
Intrigues you.
federal law identifies, I want to say it's 6 or 7 agencies in state government that can register to people to vote as part of the Motor Voter Act. That's when we do not have a registration for them. We will reach out through the state to determine whether or not they might have requested to register to vote at the agency, but for some reason, the paperwork did not get to us. So that's what those are.
Well, I'm just wondering, because I see a good 4 or 5 of them. And so what you're saying is somebody went to, say, a driver's license vehicle place, checked, yes, I want to do this, filled out whatever, and then the state never sent us anything that they needed to, or?
Right. Their registration form did not get to us, and that's one of the reasons for the provisional process, the way it's set up. So you've got the Department of Safety, Department of Human Services, Department of Veterans Affairs, Mental Health. There's a number of agencies where individuals interact for other reasons, but they have an opportunity at that point in time to say, yes, I want to register to vote.
Yeah, I'm just wondering why, I mean, is this a common problem that the state is not completing its, I mean, I see several that were accepted and that should have been registered, and I guess the state failed somehow in its duty to send us what they needed. And is that common?
It's common that we would have a few of these. What I will tell you, since my tenure here, it has improved dramatically as to how many of these we don't see with the provisional process. We get all the paperwork on the front end. So yes, there's a handful in there. We had 12 out of 235 that fit that category. That's across that 6 or 7 agencies. So, you know, I think that's a pretty good number. You're going to have some things that slip through the cracks, and what we've got here is a way that even if they did slip through the cracks, we're going to make it sure that that voter is whole and their ballot counted if they did what they were supposed to do.
Right, I guess I point out, the state seems to be very good at sending us lists of people they want us to check and throw off. They might want to spend some time making sure they do what they're supposed to get people registered. And I don't know who we talked to about that, but we can do that.
Well, of course, this is only a snapshot of people who show, it doesn't reflect, they'll tell us how many people who were registered and we got the information and everything was good from the beginning, right?
Right. tens of thousands of people registered through the Department of Safety, and we got everything we needed. We've got a handful that fell through the cracks. And we're calling out safety here. We don't know if it was safety, human services, you know, which department.
Any other questions or comments relative to the certification of these results?
My understanding is we're supposed to give 48 hours for people to come get in to return if they didn't have an ID. But I don't think we were able to do that here, right? A full 48 hours?
Well, we've got, Elizabeth is saying that, you know, from the election at, ended at 7 o'clock on Tuesday, 7 o'clock, well, really close of business on Thursday, should have been when they did that. We had people waiting, even though we had the Provisional Counting Board meet at 4. If anyone came in between that, in that 30-minute time, we were going to address that issue. Elizabeth had the folks, the Provisional Counting Board could not leave until 4:30 in the event that we had someone come in. So we tried to accommodate, you know, exactly what you're requesting, Commissioner Byrd, to make sure we did not disenfranchise any voter.
Well, I mean, I'd like to discuss why we're certifying an election when the winner has apparently already been sworn in to Congress. Does anybody know why that is, or?
Well, I'll address that. You know, regardless of what House rules may or may not be relative to this, we've got a statutory authority or requirement to do this. Now, I know there's disagreement as to when we should have done it, the timing and so on and so forth, but irregardless of what the House of Representatives in Washington does, we've still got statutory responsibility to certify the results of this election. So that's why we're here.
Well, I mean, my concern is that if we remember how we got here, I objected to moving the certification process up so quickly. And what I was told was that Mr. Goins had requested that we move it up because they wanted to swear in the person as soon as they could.
Yeah.
And I had trouble with that. I voted against it. I didn't want the staff to have to run into all the problems that we, you know, having to rush this over the 48 hours. And it turns out we didn't need to, because apparently they were just going to swear him in regardless of our certification. I mean, isn't anybody troubled by that?
I don't want to get into running debate on this, but bottom line is, I've got enough to say grace over just being part of this body here. And my goal is to do what the statute requires, like all of us, all 5 of us, to do what the statute requires us. And I understand what you're saying. They asked us to speed it up, and the idea that that was good, that was necessary for them to swear the person in. But I can't worry about what they found or why they decided what they did.
Yeah, I understand that.
Or even comment on it one way or the other. I'm here to do our statutory responsibility, and I know you are too. And legitimate question, but that would be my response to it.
I understand that. It affected what we had to do over here. It certainly,
I agree.
It certainly was the basis that we were told by the state why we needed to hurry so quickly. And it turned out to, you know, not be the case. I think, you know, as far as the lawfulness of his swearing in, that's not up to us. I do think there's House of Representatives precedents that was violated, but I'll leave that up to the whatever lawyers who want to raise that up in the United States Congress. So I can't speak to whether his swearing in was lawful by any means, because it may not be. But, you know, I guess we're going to go ahead and go forward with the certification. It's just a little bit troubling that it went down that way.
Very good. Any other comments or questions relative to this issue? Seeing none, we've got a motion before us, or do we?
No.
Okay, I'm sorry, we got
motion.
ahead of ourselves. Okay. Do I have a motion for the certify the results of the December 2nd election.
You have a motion to certify the results of the December 2nd special election for United States House of Representatives, District 7 in Davidson County.
Commissioner Dan Davis makes the motion. Is there a second?
Second.
Commissioner Dooley seconds. All right, now we're supposed to ask questions and such, but I gather everybody has asked their questions, made their comments?
The minutes will incorporate all the discussion that we already had.
Sure.
Or, I'm sorry, how about we make sure the minutes reflect all the discussion that we already had?
So with that, all in favor of certification of the general election results from the December 2nd special elections indicate by saying aye.
Aye.
All opposed, say no. And the minutes are the results are certified. And speaking of minutes, I meant to say this earlier. I'm sure, I want to commend Ms. Harrison for the way she got all these past minutes in such good order, because there were a lot of moving parts up here that day, those days, and she did an admirable job, as always, putting that together, and so I appreciate that, and I know I speak for the rest of us, so, okay. All right, so Administrator Roberts, item number 6.
Item number 6, locking of the provisional and absentee bags and bins for the Berry Hill election. We're talking 3 bags and bins that you have to lock, so we're trying to do this on the same day you have an election, as opposed to bringing you back for another day for 5 minutes worth of locking.
It's the day we've got a meeting, not the day of an election.
That's correct.
Yeah, yeah.
January 7th is our next meeting, and we would like to get those bags and bins locked on that date while you're here.
Okay. All right, is there a motion?
Yeah, move to schedule the locking on January 7th, 2026 at the conclusion of our meeting for the Berry Hill election.
Commissioner Byrd made the motion. Is there a second?
Second.
Commissioner Dooley seconds. Any questions or discussion on this matter?
I just want to point out that, as I understand it, we're also going to open the provisional bags the night of the election, or that's the goal, March 17th, and I may very well be out of town, but I've talked to Commissioner Davis, Janine Davis, that is, and I believe she'll be able to sit in for me that evening, but it doesn't look like we're scheduling that date right now anyway, but.
We're not scheduling that date until the next meeting,
Okay.
but that's the concept that we're trying to work here. So to prevent you having to come back for another day.
Okay, we've got a motion and a second, and any other discussion or questions? Seeing none, all in favor of the motion indicate by saying aye.
Aye.
All opposed say no, and the motion is approved. Administrator Roberts, relative to item 7, the call for the May 5 county primary election.
So we need the commission to take action to actually call the May 5th election for 2026 to cover those county offices that the state has no real input into.
And the list of those is in your packet with number, relative to this agenda number 7. And I guess these are the letters from the respective parties asking for the primaries for those offices.
That's correct.
Okay, all right. Do I have a motion to call the May 5, 2026 county primary election?
I move we call the May primary on May 5th for the county primary elections of 2026.
Motion by Commissioner Janine Davis. Is there a second?
Second.
Second by Commissioner Dan Davis. Any questions or comments?
To Commissioner, not to Commissioner Ailey Roberts. So just to make sure as I'm going through this, as I'm reading it, both parties have satisfied their requirements to do so, correct?
Yes, both parties sent the letter with the appropriate language to cover calling the primary.
So
Commissioner Byrd.
thank you. I think we probably should put on the record here this issue of redistricting if it happens, just so that the public is aware of the concept that, just to bring everybody up to speed to some degree in the public, this is my take on it, but, Nashville not wanting to limit the number of council districts it has, but the state is forcing Nashville to limit the number of council districts over Nashville's objections. But that's in the court process right now. That's in the legal process. And I do think that depending on when rulings happen and what those rulings are, could really complicate the ballot, because it would be that would be on the May 5th ballot then, right? Not the August, because it says the executive committee, council district 1 through 35.
Right, the executive committee, election falls in May. So we're electing in May 70 Democratic Executive Committee members, 2 for each council district. Should that change to be 20 council districts instead of the 35, the Democratic Party would really need something to give them the authority or the guidance as to how they will undo the people that were just elected May 5th.
And can you explain how the Republican Party is different?
The Republican Party, they have just an internal vote as their members, as opposed to an actual election.
And so it doesn't really impact them.
It will not impact them, no.
Okay, well, I mean, it's something to note. It's something that the public needs to be aware of, is sort of just one more cascade of issues that we're facing with the state.
Any other questions, comments on the call of the county primary election? Seeing none, all in favor of the call indicate by saying aye. Aye.
Aye.
Aye.
All opposed say no, and the motion is adopted. All right, Administrator Roberts, if you would share with us about the petition signature challenge provisions that are in our folder.
So if you'll look at copy number 8, that's where we're speaking to the signature challenge. What we're trying to do really is define kind of the rules for candidates. If you want to file a signature challenge, here's how it's going to work. There's nothing out there right now, and our recent experience with the signature challenge, it was challenging. So I've got a document here. Here's the paperwork for just those 2 challenges. So we killed not just a tree, but a forest by the time we make copies for everyone and whatever. We're trying to put it in writing that we can hand out on December the 22nd when candidates pick up their petitions, so that they know ahead of time. If you want to have a signature challenge, here's the steps that you need to take and how it will happen. And we've worked with both Ms. Ecke in Metro Legal. We've worked with Coordinator Goins at the state to draft something that we think will be of benefit both to us and the candidates as we move forward. And I'm happy to answer any questions you might have.
All right, to get this properly before us, do I have a motion to adopt the petition signature challenge procedures?
You have a motion.
Got a motion
Yes.
from Commissioner Dan Davis. There's a second. I'll second. So, all right, so are there any questions, comments?
Yeah, I got a few just to go through it.
Commissioner Byrd?
And I do understand that you want to do this on the December 22nd, and I hope we can, but I have worked through it over the, You gave it to us the other day, and I know it's been traveling around some, but I've been trying to work through some of it. And I do have some issues and some questions that I think we need to make sure Metro Legal and others deal with. I mean, I don't think it'd be the end of the world if we hand it out on January 7th and tell the folks there will be, procedures coming. But hopefully we can get it done today. I mean, we can get it done today. Nikki, I'm going to be kind of referring to you a little bit here, but what is is there a statute that we can reference here at all on a challenge to the signatures? I mean, is there a statute that governs any of this?
I don't think there's a comprehensive, like, one statute that comprehensively,
Sure.
but this is just to, obviously, the commission has the ultimate authority to determine whether the, appropriate number of signatures have been, provided on a petition, to qualify a candidate to be on the ballot. But, there are statutes that address petitions, and all that, but this is just a comprehensive process, really, that notes the commission's role as kind of a quasi judicial body to make the final decision when there's a challenge that, a signature, to a particular signature on a petition.
Okay, so I think the answer is, I mean, there is no statute.
That comprehensively
Okay.
addresses every single thing.
I
on this.
understand that, but are there parts of the statute that not comprehensively address it that we could just take a look at? I don't know right off. I mean, because it sounds like, I mean, we have the authority as the election commission to deal with candidates that are gonna be on the Nashville ballot. And
think
that's
that-
why we take that authority
Right.
and we, can deal with any challenges that come up about people that are on our ballot, right?
Right.
And that's the,
Yes.
Your responsibility is to determine that everyone on the ballot is qualified to be on the ballot.
Exactly.
And that's in the statute. It really doesn't explain much,
Okay.
not in the level of details as far as signatures. The signatures, and Nikki, make sure I'm not out there, but it really deals with a signature challenge of a voter when they're voting, not when we're qualifying a
right.
candidate.
right. All right, so,
Wait a minute, Ms. Zeki, did you want to follow up, say anything as to that?
No,
Okay, all
no.
right, all right, I just want to make sure,
Yeah, no, no.
all right. Commissioner Byrd?
okay, so I have a couple things. I mean, first of all, I think if someone is going to challenge signatures like we've had in the past, and I wasn't a part of the prior challenges, so I would be open to hearing some wisdom from some of you folks that had to deal with it. But, I don't think you ought to be able to challenge, let's say somebody needs, 25 signatures, I guess, usually for the petition, for the candidacy, and you get 50 signatures, and somebody wants to come in and challenge 10, we shouldn't have to go through a process at all if someone doesn't challenge enough signatures under this process where it would make a difference. I mean, do people agree with that?
Well, I think that's,
Whoa, let's-
go ahead.
Let's be
Yeah,
careful.
or
All right, so Commissioner Davis, do you have a response to that?
Yes. Apologize, Commissioner, Chairman.
worries.
Sorry. In his example, and A.W. Roberts might, can tell me if I'm wrong. If there's more signatures that are valid than our challenge, it's not even gonna be an issue because that person will be qualified. Does that make sense? So the issue, so since you asked for wisdom, the issue that came up the last time that we were here for this was that the signatures that are being challenged bumped up against the numbers that would have qualified them for being on the ballot. Does that make sense? So in your example, they turn in 35, you're challenging 10, they still have 25 that are legit. They're, if that's the standard, it doesn't matter. They're already in. Does that make sense? It's only if it bumps below the number, and I think the example you're trying to set is the issue. So if they turn in 50, someone wants to challenge 10, and the other 40 already qualifies them, it's a non-issue.
I agree it's a non-issue, and I'm just wondering if we want to write in here that before, and, you know, that the administrator, the AOE, would determine, has there been challenges to enough signatures, that would, I don't know what the word is, but that would, you know, even qualify the need for a challenge because it's already qualified under their signatures. Or do we need something like that?
I
Commissioner,
think,
I'm trying to avoid the
sorry.
frivolous type of meritless.
yeah, this
stuff.
really contemplates situations where whether or not this candidate has the sufficient number of signatures is at issue. So so that's really where what this contemplates. So if, like you said, if the petition has 50 signatures and someone comes and says, 10 are invalid, and I want to challenge them, the response of the AOE will be like, okay, regardless of your challenge, there's sufficient signatures to move forward. So, there'll be no need for this to come into place. So,
I agree. I'm just trying to stop challenges that could then set off a legal process, though, that may otherwise go through a legal process that doesn't need to, that would delay us.
I don't think we've had those, sorry.
I mean, I understand you haven't,
let's,
but
you
as
know,
long as we can make that clear, I think people can always go back and read what we've said here and understand that, we don't see that as a valid challenge that ever needs to happen.
I think, following up on what you're saying, that the AOE would communicate with that person making the challenge that even if we have to go back and check, more signatures, so that the person will know, even if you challenge 10, they've got 12 good ones to go, or 15, or whatever, so that we head those off at the pass, as opposed to getting, too deep in the challenge process right off the bat.
And I think we try to deal with the timing here to some degree. So my next question, I have two more questions. Let me just throw them out there.
can I ask a question kind of related to that, to make sure I'm understanding what you say? As a matter of practice in the past, when staff is reviewing the signatures to determine whether they've got enough, was the practice to check them until you found out that they had enough? Or did they check the whole petition?
Typically, we would check up until we got 25. But I think what we're describing here is, if I'm notified by a candidate or whoever they want to challenge, we would then go beyond whatever they've turned in, so that I can tell the person they've got 40 that we've, so you're going to need a big number to challenge. I think it's just going to be communication. And a lot of this is just sharing with the candidates, here's kind of the rules to play by, as opposed to not having anything and we're surprising everyone as we're trying to work through the challenge.
Is it okay?
Yes, sir, Commissioner Byrd.
I agree, and if anything, I don't want to see people coming in here with meritless challenges, and I don't want the staff having to do it. So another question I have is there a fee shifting issue we could do here, Nikki, where, well, you already should hear me out. I think if someone challenges, it might lead people to then make meritless challenges to signatures so that they can get to the process when they really don't have a basis. That's what my concern is. And I want to know what the ramifications should be to someone who wastes our staff resources and time and money for that challenge. I'd like it to be that we can then, they need to put up some sort of bond or something, and that we could then, send them an invoice at the end of it.
Ms. Akey,
Yeah,
would you
that
wanna
is,
address that?
the commission doesn't have that authority under the law.
But we don't not have the authority.
Well, those type of, conditions, et cetera, are imposed by law. So like bond, et cetera. So that's not something the commission on its own can just impose on individuals that are appealing a matter before the commission.
Okay, well, I hear you. Something to think about maybe for down the road, though, if we can figure it out.
Okay, before you get to your next question, Commissioner Davis, do you want to be recognized?
Yeah, I to Commissioner Bird's thought, I appreciate it, but I think you also could be skating to that slippery slope of a constitutional issue of poll tax. And the whole idea of, because you're now limiting the ability of people to eventually vote, which is something I don't think we even want to come close to.
I don't know if I see that. I just don't want meritless challenges to signatures.
And I
don't
agree,
think-
I agree with
yeah,
that idea by a mile.
Yeah. The other I have two more questions, sorry, let me put out
I
there.
thought you had two last
I
time.
know. So any person, the second bullet here says any person who resides within the jurisdiction of the office. I don't think we have any authority over people outside of Nashville. I think it has to be I think it should be a registered voter in Nashville is the only person who has the authority to bring a challenge. And seeing as how we already talked about this fact that there's no statute here that deals with this, I think we do have the ability to do that. I think we have the ability to say, I mean, we're saying any person who resides within the jurisdiction, and no one, if you want to tell me where that comes from in the statute, it ought to be any Nashville registered voter. We shouldn't be letting people come in here from another county and challenging our ballot or
Well,
signatures.
it's talking about a person who resides within the jurisdiction of the particular office, so it will not be, whatever the office may be.
Yeah,
So, I mean, it's.
I don't think somebody
Whoa,
from,
whoa. Can let Ms. Ecke finish that, please?
So, it pertains to the area that encompasses the candidates, right, that, for which this commission, makes decisions regards to their qualifications to be on the Davidson County, on the ballot of
Yeah.
Davidson County. So, I mean, whenever the, commission is presented with credible evidence that there might be an issue with someone's candidacy, they can look into that issue, really regardless of who may have brought that initially to their attention.
no, I understand, yeah. I understand what it says, and just because Metro Legal tells us, I mean, we don't always have to follow what Metro Legal thinks here. I will make a motion. I think that should be a Nashville registered voter can bring a challenge. I think that we're well within our rights to do that. I don't think we need to hear challenges, for example, in this race, since I don't think anybody from Montgomery County should come in and challenge the signatures that were needed in Nashville. But
Administrator Roberts, and then I'll call on myself.
So I think that particular phrase is more a catch-all, because if you're running for a statewide office, you're filing your paperwork with the state. Now, it may have originated with us, but we will forward it to them. They're determining whether or not there's the 25 signatures. We're just kind of a conduit. So if a signature challenge came to us, challenging a Davidson County resident, we would forward that up to the state. The state would ask us to verify the signature, but they would be the one making the decision as whether or not there's enough ballots for governor or senator, those kind of roles.
yeah, for statewide type of,
Right,
I'm
right.
talking about Nashville.
And the same thing on the race we just had. We're not the whole. We're only a piece of it. But if we had a challenge brought to our attention, we would forward that to the state, let them direct us to check the signature of the Davidson County resident. We'd forward it back to the state, and they would be making the decision.
Okay. I guess I get that.
Well, so are you off that idea then? Because I want to address it if you are.
I get it if it's, say, the U.S. Senate or Congress, and that means that somebody in the state's going to decide. I I don't want any questions, though, about a race that doesn't touch other outside the county.
Well, let's bring it closer in. I mean, if we're talking about two different legislative races, not like a legislative race in the 52nd, you know, this language limits who can challenge that. Somebody in the 51st, under your idea, would be able to challenge a petition for somebody running in the 52nd. But I think the way it's drafted, it would limit it to people who are residents of that 52nd House district.
That's fair. I mean, we could limit it more even though and say a registered voter who resides within Nashville within the jurisdiction. Why should it not be a registered voter making a challenge?
Well, I mean, that's an issue, Commissioner Davis.
All right, so if they challenge it when they're not registered and they decide to register, so is this ex post facto or what are we doing here? If they're a citizen, they're a citizen. Citizens have rights. You like to point that out all the time. So why are we limiting their rights, which in turn would be infringing upon a person's right to vote and or determine the election based on the rights that they have?
Yeah, I mean, I think you're just trying to debate. I'm trying to help. I'm with you.
Gentlemen.
I'm with you all on, I'm with you.
Gentlemen, all right, I was trying to get away from this, but I was trying to get away from this, but I'm gonna ask everybody not to speak until they're called on, because we're getting into running debates here and all that, so, just kind of work with me on that, and if somebody behind me is, you know, hit me in the back of the head with a book or something, but let me know. So Commissioner Byrd.
All right. Yeah, I'm trying to help us not have to deal with challenges that don't make sense. I'm not trying to, get engaged in something other than that. And because I know the staff here having to deal with it and us having to deal with it, we don't want to get in the business of becoming that type of body, having to deal with it all the time is what I'm trying to deal with. So I don't know, maybe we leave it the way it is. And if you're within the jurisdiction of the office, that probably works. The last one I have is,
One second, did you want to address what he was
Yeah.
just saying?
Right, yeah, I mean, I think, keep in mind, we've just established kind of a paperwork flow for those statewide offices so that if you are gonna challenge, here's how you have to do it, and we're gonna flow that paperwork up to who's responsible. We're not gonna accept any more work than we need to.
All right.
the last one I think,
Commissioner Byrd.
the last one I have is, that bullet where it says all signature challenges shall be adjudicated by us, which I think is right, in conjunction with the state coordinator of elections. I don't know why we have that.
I would suggest Commissioner Davis.
I think Ms. Ecke had
Oh, Ms. Ecke.
On the Tennessee code, there's a authority given to the coordinator to make sure that only qualified candidates are placed on the ballot. So when these challenges are called, generally, the coordinator or a representative would appear and, in conjunction with the commission, review the matter, but the commission, generally makes, the decision. But, the coordinator has a role in determining statutorily, in making sure that only qualified candidates are placed on the ballot, and has a role to kind of advise the commission on how to perform its duties under the statute.
Okay.
Commissioner Byrd.
I doubt the state coordinator of elections was involved in the prior ones that we did. And I don't see any reason to,
Let me call on you.
yeah, and tell me what happened there, because I want to be very clear about what their role is, and I don't know if there is much of one. Other than, of course they are supposed to, they have obligations under the statute, but when it comes to a challenge, I don't know that we have to do this in conjunction with them.
Administrator Roberts.
In the previous challenge, the role of the coordinator was kind of making sure we had the process in the right format. They were here at the challenge and asked questions, but only the commission members actually voted. So it's back to you five will be the only people that make the determination here in Davidson County as to who's qualified to go on the ballot.
If I may ask you a question relative to this, I think I hear what you're saying, the use of the word in conjunction with, because it infers that we are at some level waiving our authority or something of that sort. But I agree totally with what Ms. Ecke has said about relative to the coordinator's office. The coordinator is the responsibility. He's ultimately the one who determines election law interpretation and such. So I think he certainly, whoever's in that role has a role to play. Would you be any more comfortable with the word in consultation with the state election coordinator was in there?
I don't think so. I think that might be where, I mean, I don't think the state coordinator of elections is the final word on the law either. I mean, we would, I don't want to get into that, but, I'm trying to think of something better.
I'll disagree with you on what the thought of the election coordinator. I'm sorry, thank you so much. He absolutely has the authority. He is it says he authoritatively interprets the election laws. That's one thing I remember. So I think to suggest he doesn't have a role in this I would have to disagree with that at some level, whether it be consultation or something. But to your concern, the matter also says that the decision of the election commission shall be considered final. It doesn't say anything to give any inroads that the coordinator has some sort of role to play other than advisory relative to what the statute requires him or her to do. Commissioner Byrd.
I mean, I just think it'd be easier to take it out. That doesn't mean that they would not have whatever role that they've always played in something like this. I'm just trying to not, I certainly don't think that they can come in and overrule what we do, for example. They can't.
Ms. Ecke, let me ask you a question on procedure, if I may. We've got a motion and a second on the table. If to address, to amend this in some way, and I'm just asking in case somebody does want to do this, since Commissioner Byrd has suggested it, is it appropriate at some point just to accept a motion to amend the motion that's on the table, or what would be procedure on that, please, ma'am?
Yeah, so is the motion on the table to approve this?
Yes.
Yeah, so that can be amended. Again, if it's, if the person, it can be a friendly amendment if the person who made the motion agrees with the amendment. If not, then, it requires a vote.
Okay.
So, okay, I can make a motion. We've heard it on. Here's what I would say. I'm not trying to remove any power that the state coordinator already has under state law. Absolutely not. Can't do that. And not trying to remove any role at all. I just think it's confusing to add it in here because it all of a sudden starts sounding like something that we are adding.
So,
I don't think there's a need for it. And then whatever role the state coordinator has under state statutes, he does. I mean, he or she does. Has that role without the words. We don't need it. So I would just make a motion to remove in conjunction with the state coordinator of elections or designee in a notice meeting. Or I guess I would make a motion to remove in conjunction with the state coordinator of elections or designee. And leave in a notice meeting, because and understanding that this doesn't, not changing what the state coordinator's rights would be in any situation, but trying to not add it into the process without understanding what it is.
Okay, as I understand our situation, Ms. Eke, correct me if I'm wrong, we'll have to get a second on this before we discuss the point that's.
Sure.
Yeah, okay. So is there a second? I see no second. The motion dies for lack of a second. Or I'll,
I'm sorry, so the second would be for his amendment? Is that what
Yes.
we're asking? Okay.
Yeah.
I'll second, just for then we'll have to go into discussion again, I guess, right?
the second's been made by Commissioner Janine Davis. Is there a discussion or questions? Commissioner Dan Davis.
Okay, so in looking at this, and like I said, and part of this is coming from the past experience of being in this whole deal. The coordinator of elections, you know, whether from Mark Gowen's office, him or a representative, is going to show up either way. So I guess my whole issue is that the language in the current signature petition procedures is like, I guess we're arguing, it's a moot point on one level. In all honesty, that's why I'm like, why not just leave it in there? If you want to change the feel of the words, that's fine. But it's like, because now striking it out looks a little bit suspect. And maybe suspect might be a strong word. And like I said, really, I'm just saying, the heart of this is this. Hear my heart. The state coordinator's office is going to show up no matter what. So us saying it, you know, you might as well just let everybody know what's going to happen anyway. But as it's been pointed out, the final say is when we, literally since I was in the last one, it's going to be the five of us, no matter what happens. They can suggest, pound the table, and whatever else. It's still going to come to whatever we decide and how we vote.
Commissioner, Ms. Eke, then I want to ask you something, if you're all right. Ms. Eke?
Yeah, maybe something to consider is using the word with advice from the state coordinator of elections or designee in a notice meeting, only because, you know, why I'm suggesting that, maybe as a way to resolve this, is the TCA 211-202 states that the coordinator of elections.
Wait, what is it?
211-202A, subsection 3 and 4, A, 3 and 4, says the coordinator of elections shall advise election commissions, primary boards, and administrators of elections as to the proper methods of performing their duties. The coordinator of elections shall authoritatively interpret the election laws for all persons administering them. And there's a 211-202 subsection A12 says the coordinator of elections shall ensure that all election commissions with the state shall prohibit any person from becoming qualified to have such person's name placed on any ballot wherein such person is seeking to be nominated or elected to an office for which such person is ineligible, or to da-da-da-da-da. So there's various language, and I think there's another specific one that talks about only qualified candidates.
Okay,
I'm trying to read through all of it, but,
Well,
so
wait a
anyhow.
Okay. I saw you shaking your head earlier when Ms. Eke was giving some suggestions. So let me ask you this, instead of going.
yeah.
Would you be willing to amend your motion to remove the language in conjunction with the coordinator of elections? In addition to remove that, add another bullet that would require the AOE to invite the coordinator to any hearing on this.
I think I'd be up for that. That's a little better. And my real problem here is that it says shall be adjudicated, in conjunction with, and it makes it sound like they were supposed to be included in the deliberative part.
Yeah, well, yeah, okay.
That's my issue.
So that's.
I'd be fine with that.
So that becomes part of the amendment, since it's a friendly amendment. Would you, the second, Commissioner Janine Davis, you're okay? So the motion then, therefore, before us is, which bullet is it?
It's the 8th. Is it already in there somewhere?
Where is it? Point it to me. Oh, yeah, okay. Item 8, you'll strike the language, in conjunction with the state coordinator of elections or designee. And then you'll also add an additional bullet that says that something to the effect that requiring the administrative elections to invite the election coordinator or his or her designee at the hearing.
To be present at the hearing.
Yeah,
I'm fine with that if it doesn't say it somewhere, if it doesn't say it somewhere else already or something, yeah, okay.
okay.
And just for the record, though, this is the public, I love our legal counsel here. I disagree with the 12, what that really means here. But I don't want to get in a debate with you about it, and you're not on the commission. I'm not trying to debate. I'll talk to you about it later.
And there's
But
another
that
one.
provision, no,
I can find another one.
I'm not here to debate you.
That,
Ms.
that
Hexter.
actually goes to qualification.
Okay,
But,
I'm not doing that.
Okay.
What that bullet means is that they'll make sure that we actually hold a hearing and that we don't just ignore it.
Well,
That's what that
if we've
means,
got
but
a
whatever.
motion we can all feel good about, let's address
Yeah.
those other issues at some other point. So, given that the motion has been adopted through friendly amendment, as I just briefly mentioned earlier, are there any questions relative, or answers or suggestions relative to that current language? I see none. So, given that, we'll have a vote. Is everybody clear on what the motion contains and how it would change this before us? Basically, it addresses the issue of where the language about doing our work in conjunction with the election coordinator or his designee, we would strike that, and in its place, in a separate bullet, we would make a provision that says the AOE will be required to invite the coordinator of elections or his designee to the hearing on the issue. So, yeah, so, all right, given that, everybody's clear,
Now we're back on the original motion.
as you amended. Commissioner Davis, Dan Davis.
Well, if we have to vote on that amendment, then we have to vote on.
No, I think we can vote,
We
make
can vote.
one vote.
Okay.
Because they've adopted as a friendly
Okay,
amendment.
friendly amendment. Okay, there we go.
Okay, good, but thanks for asking the question. All right, given that, all in favor of approving the challenge procedures of signatures as amended, indicate by saying aye.
Aye.
All opposed, no. Yes, we have adopted it. Thank you, Commissioner Byrd, for your questions and insights, and I think it's made the document a little bit better. So, with that, we'll go on to the next one, to approve the candidate residency challenge procedures. Administrator Roberts.
Commissioners, this policy would follow along the same lines of the signature challenge that you just passed. It puts in place for the candidates the guardrails, the guidelines. If you're going to make a residency challenge, this is how it will flow. And ultimately, it would come to you to make that final decision. But we kind of define what we're looking for so that you will have the appropriate documents and whatever to make that decision.
All right, with that, I'll entertain a motion, and I might suggest that the motion provide that in item 5, we remove the same language we removed in the previous document. And we could add that extra bullet, but I think it's by statute, that office is
Yep.
authorized to be here. So I'll leave that to the discretion of the person making the amendment, the motion. So do I have a motion on this item?
Sure, I'll make a motion, but I guess the motion will be to approve this, but change in the same way we just changed the signature challenge to remove the words "in conjunction with the state coordinator of elections or designee," make that a separate bullet in the same fashion we've done in the other way, to be consistent.
All right, we've got a motion. Is there a second?
Second.
Commissioner Dan Davis seconds. All right, any discussions or questions?
No, other than I'd point, same issue, it does look like we're gonna be, it is somewhat limited because the person who resides within the jurisdiction is the only person who would have the ability to bring a challenge.
All right, any other comments? Seeing none. All in favor of the motion to adopt the residency challenge procedures as provided before us and as amended by the words of Commissioner Byrd, indicate by saying aye. Aye. All opposed say no. Motion passes. So that was a hard one.
I don't know, well, after we had the other discussion, it helped.
All right, Administrator Roberts, the item number 10, approve the Election Commission Personnel Manual.
So what we're trying to do here is, let's just call it update the manual that was last approved in 2003. It's been a little while. We thought we should redraft this, put it in language that is easily readable by especially a brand-new employee so that they know kind of what the expectations are, and if they have an issue, where do they go to get resolution to whatever that issue might be. I'm open to any questions. I want to thank Ms. Ecke for helping us put this together and offering suggestions as to specific language that we needed to leave out because it wasn't clearly defined. But I think the package that you have before you should make it much easier to understand from an employee standpoint, kind of the day-to-day expectations and what it's like to be an employee for the Election Commission. I'm open for any questions that you might have.
All right, in order to get this properly before us, do I have a motion to approve the Election Commission Personnel Policy Manual as presented to us by Administrator Roberts?
Motion.
Commissioner Davis, Dan Davis
Yeah,
makes a
motion to
motion.
approve, yeah.
Is there a second?
Second.
Is second by Commissioner Byrd. All right. Commissioner or Administrator Roberts indicated his willingness to answer any questions we may have. So are there any questions for the Administrator or any comments or suggestions? Commissioner Byrd.
Is this, was there not a policy manual at all before? Or, I mean, I guess, or was there like, is there like a red line version of this?
There wasn't a red line version, mainly because it was from 2003. And what it encompassed was, instead of having essentially our own, the title says it was our own, but it included a lot of just general Metro HR kind of policies. And what we're trying to do here is separate out for our staff. Here's what makes us a little bit different from your typical Metro Nashville employee, because those are out there and any employee can see those. We just want to make sure they know kind of what the rules are for us. And, you know, I'll give you an example that you wouldn't typically think of, but something as simple in the dress code as don't wear anything with writing or graphic designs because you don't know what words might be considered partisan by the people coming in our office. The people that are coming in to get their driver's tags, they don't care. But in our office, it causes a problem. The person calls us, calls the state. Those are the kind of things that we're trying to address to make sure our people know we're a little bit different than your regular Metro employee.
Commissioner Byrd.
That helps. I do want to note I think you mentioned about the at-will employment, but I do want to note for the staff here today that this provision also in Chapter 2 says that all policies by the Davidson County Election Commission shall be administered in such manner as to comply fully with all equal employment opportunity laws and regulations. And I would, point that out, that that includes any sort of termination type of issues would need to follow those laws and regulations, and those protections are in place. And I'm sure Ms. Hickey would agree with me, right, that the commission, even though we're a little bit different, still has to comply with all federal, state, and local employment laws.
Ms.
Yes,
Ecke.
sir.
All right, very good.
Okay. I note, though, the one at-will that's not an at-will are the machinists. And we ought to point that out for the public. And that's listed in here because the machinists are hired by each party. And
Right.
the AOE does not have any control over the machinists. The Democratic machinist is hired by the Democrats. The Republican machinist is hired by the Republicans. And that is who makes the decisions when it comes to that. And it says, looks like that's been written out pretty clearly here. But I'm really just saying that to point out for anybody, any nerds who listen to the Election Commission meetings and want to get the background.
And I think the state statute would override, just like you said, any employment practices that are in state law where it's defined that there's a Democratic machine technician and a Republican, and the AOE, they're hired by this body.
Any other comments, questions? Seeing none, we'll vote on the motion to approve. All those in favor of approving the Davidson County Election Commission Personnel Policy Manual as presented to us indicate by saying aye. Aye. All opposed say no, and the motion carries. With that, I'll take the lead on the next item. I think at our last meeting, there was some discussion or question about the possibility of setting up an arrangement whereby we could continue to have the benefit of Mr. Roberts' expertise, should that be necessary. And in light of that, we've put on the agenda to discuss this idea. And I guess that the idea, the way it would operate, as I understand it, would basically be that we would authorize soon-to-be Administrator Richardson to consult with Mr. Roberts as necessary, should there be some issues, some thing that in which Mr. Roberts' skill, knowledge, and history would give him some unique perspective that we could draw from. And it would be basically, we'd have to come up with some sort of agreement that would probably provide for a compensation rate, which I would suggest should be the equivalent of what his hourly rate would be based on his current salary. With that, let me ask, before we can have it probably before us for discussion, questions, and what have you, is there a motion to approve entering into an agreement with Administrator Roberts to serve as a consultant on an as-needed basis? So with that, I understand, am I out of order, Ms. Ecke?
No, I just want to clarify that, before the motion is made, that really what the commission is doing is authorizing his employment on a part-time basis, not really a procurement. Because if it's a procurement, it will need to go through the procurement process, through purchasing and through the competitive bidding requirements. So this will be actually, the motion really should be about approving him serving as a part-time employee, as needed. He'll need to work less than 20 hours a week in order to keep his pension. But it's going to be an employment relationship. If you want to do it as procurement, then you need to go through purchasing.
Thank you for that clarification, for making it much more simple. The motion would therefore be to approve an arrangement for Commissioner Roberts to be a part-time employee to provide any assistance that may be needed relative to his experience, would be consistent with Metro policy or?
Yeah, consistent with Metro pension rules.
Okay. That was a very poorly worded motion on my part, but I have faith in Ms. Harrison that she can make it sound flowing
Yes.
and beautiful. So is there a second to that motion?
Second.
Okay, you can all second this one.
So who's got the second? Oh, Commissioner Byrd has seconded the
Second.
motion. All right, so is there discussion? Commissioner Dan Davis.
Okay, so I'm for this idea. I just want to make sure that since we got everybody here in the room at the moment. So basically, it just needs to read something to the effect that approval as part-time employee, no more than 20 hours a week per, and it'd be at the call of the commission.
Less than 20 hours
Less
a
than,
week.
okay, thank you, that's what I said, okay. Less than, that's why I was writing it, I was trying to write it down, that's why I'm asking questions. So less than 20 hours per week at the call of the commission. Does that sound the generally correct, or is it gonna be rolling, I'm asking?
At the call of the AOE, right?
Yeah.
I'm just
Okay.
not, like, we don't have to take any further
Right,
action. Yeah.
okay.
Administrator Roberts, did you want to say something?
No, I just wanted to make sure that we were giving John an opportunity, if he had some big issue, he could just call me.
Right.
And, not have to have a commission
Okay.
meeting to.
Okay, so I was trying to look for wording, so thank you.
Excuse me, any other questions? And I see Commissioner Dooley does have a question or comment. You're recognized, ma'am.
Yeah, as this is written here, I'm opposed. Yeah, as it's written, and when I was reading it yesterday, I'm opposed to it. And I want to make sure that everybody, I think, knows it has nothing to do with Jeff. I'm one of Jeff's biggest supporters. I just think that, I think that there can be some issues with, accountability, authority, allegiance of staff, because Jeff's been here so long, and he's, those are concerns of mine. So I'd like to have more time to discuss it, or to review it, or something, because right now, in my mind, a clean break sometimes is a lot easier to deal with. I'm not opposed at all to the idea that I think it's wonderful to have Jeff available for call and payment on that, but as a part-time position, I think there's the potential for blurring the lines, and I want to avoid that if possible.
Well, I would, I think we do, I think where we're going with this, I think everybody's interest and concern and purpose is to ensure that Mr. Richardson and his staff are placed in the best possible position for success. Now, I hear you say that with Commissioner or Administrator Roberts' continuing involvement at some level, that could create problems within the staff of some way. I would disagree with that. However, you indicated you would like more time to think about it. If we put it off to January 7th meeting, would you, well, let me ask you this. I gathered what you said, that you need a little more time to think about it, that if we extended it, that additional time of 30 days, or however many days it is, that you would possibly consider and perhaps be persuaded one way, not to commit you that you would be persuaded, but you're open to discussion.
Oh, yeah,
If we
yeah.
opened it, okay. Well, with that,
Mr. Chairman, let me just make a comment that might help Commissioner Dooley. I have no interest in working 20 hours a week. I have no interest in having an office.
Yeah.
I'm more, if John calls, and let me give you an example. Let's just say the Supreme Court rules that we're going to have 20 council districts. John calls and says, can you come in and make sure we've got everything going in the right direction? That would be me coming in and helping, not, telling the staff what to do or whatever. I'm just providing some assistance that everyone feels like they've got all the bases covered.
Yeah. I think I understand that. I've seen transitions in leadership happen in the past where there was a blurring of the lines. I know you, I know you don't want to step in and do anything. I'm just wanting to make sure that it's very clear to avoid any kind of potential blurring of the lines that could happen.
well, with that, and in hopes of being able to come to a unanimous decision on this, I would suggest, unless there's some, oh, I'm sorry.
It's okay. So, Commissioner Dooley, would you, first, before I ask Commissioner Dooley, Ms. Ecke, could we create a, part-time job description, if you will, or, very loosely, job description, or some type of, that's the only word I can think of is job description, right? Or job description, since it has to be a part-time position versus a consultant position, because consulting contracts and job descriptions are different. So, sticking with that, is it our responsibility to then create that? Or how would that happen?
You could, you can ask the new AOE to do that, because it appears that this will work where the new AOE, at his discretion as needed, will seek out the services of Mr. Roberts.
And that's what
So-
I'm thinking. I'm wondering if that will help Commissioner Dooley, if that would help to, I guess, put the parameters and the guardrails around what you would like to see AOE Roberts do, and then how AOE Richardson would contact him for, and just give some guidelines, if you will, around that. Is that something that you're thinking about?
Oh, yeah, yes, sort of, but not totally. I mean, I think if AOE Richardson wants to contact AOE Roberts, then he's totally free to do so. I'm not saying that there should be any boundaries in between there. I'm just saying that the wording here, I think, could, implies that there's, to me, it implied that there was going to be a presence. And you're going to have two people. And I don't know, I had red flags going up from some past experience, so I just trying to clarify that.
Okay, so I understand. So I think maybe it would help if there were, again, some guidelines that we then
Yes.
put together.
Yes.
I think AOE Roberts just says he doesn't want to be in the, he doesn't want to be in office. So
understand
unless
that.
he's called to come in, that's when he'll be in. But, so I think maybe that's what we need to consider at the next meeting, between now and the next meeting, is drafting some guidelines.
Yeah, I think that's a good idea, and I would charge soon-to-be Commissioner or Administrator Richardson to sit down and just think through circumstances where he might envision needing insights, and do that in consultation with Administrator Roberts relative to what he's willing to do to begin with. And I think we would want to be clear, I don't think anybody envisions Mr. Roberts being a presence in the office. I mean, in a way that would disrupt Mr. Richardson's authority, but again, provide a resource for Mr. Richardson in a situation such as Mr. Roberts pointed out on that, a very real situation about the prospects of having to redo redistricting for the Metro Council and such. And so I would charge Mr. Richardson to work on that in consultation with Administrator Roberts to perhaps address the concerns Ms. Dooley may have, and at the same time clarify for all of us what that might look like and how we could see how beneficial that would be, not only for Mr. Richardson, but for the remainder of the staff as well. Ms. Dooley, do you have an additional question, comment?
Yes, my comments, my concerns are more preventative. It wasn't like I was anticipating anything, because basically, in a nutshell, we're right now in like a midterm election year. And we've got the council thing coming up as well. So there's going to just be a whole lot of activity coming up. I just didn't want to introduce the potential for any other thing during what's going to be a hectic year anyway.
Okay, very good. But I think in fact that the fact that we've got the midterm elections coming up is an additional reason for the concept. But with that,
Yeah,
Commissioner Byrd?
well, I'm a little bit worried that, does his employment end at the end of the year? And we don't meet till January 7th?
Someone else needs to answer when.
I don't know.
Jeff, when is your last day? I don't know.
It's the last day of the year, right?
Right, it's December 30.
Is there, I don't want to run into an issue of, even if it's only a week or two, some issue with, his employment that makes it difficult for us to do a part-time employment. Well, here's what I would request, Commissioner Dooley. Why don't we just make the motion to do both, that we're going to hire the part-time Mr. Roberts, because it is, I mean, I'm very worried that a lot of pieces are going to be moving here pretty quickly, and I don't want him to be called on for free either. I don't think that's that fair. Why don't we hire with and set and instruct the new AOE to put in place, sort of bullet points of sort of the do's and don'ts, and make it very clear in the motion that if there's any disagreements whatsoever, and I doubt there ever would be, that, the AOE is the one who has the final say and the staff. I mean, couldn't we do that today, just with that way we don't have to run into the 7 days?
Commissioner Dooley?
I'm not real sure I understand what the 7-day issue is here right
Well,
now.
He
Well,
wouldn't.
let's get clarity on that issue. Let's get clarity from Ms. Ecke. I think that the issue, the question that Commissioner Dooley may have is, and Commissioner Byrd referenced it, does the fact that he goes off payroll for 7 days or whatever adversely affect our ability to bring him on as a part-time employee after that?
No, not that I'm aware of.
Okay.
no.
Thank you. So, Ms. Dooley, I think that what Commissioner Byrd is suggesting is that we go ahead and approve the concept, and that in the meantime, Mr. Richardson, in consultation with Mr. Roberts, comes up with the bullet points and the process that perhaps we would approve at some later date.
That's right, and we can even say the AOE, in fact, it's he gets to determine it. I mean, he's the new AOE now. He determines the rules of the road. So I don't even think we need to, it's not something we need to approve. He hires other people. I mean, we just talked about, we just did at-will employment policy manual, okay? What that means is that AOE Richardson can hire and fire people. And then he tells them what to do all the time. This is no different here. So he's in charge, and we're gonna instruct him to deal with his employee. And I'm frankly just, I don't wanna deal with this. I'm gonna make the motion anyway.
Well, we got a motion, so you're gonna amend the motion?
I think it was your motion, right?
So what are you proposed to?
Well, I mean, I wouldn't mind talking about it first. If you wanna just, is there some other issue going on that we need to be aware of or something? Or can't we, we've hired a new AOE. We went through that process. I think even when we hired him, maybe the motion, I can't remember, we'd have to go back to the minutes. I think we discussed the concept of that with somebody so new that we got a unanimous vote because we understood that he, during this very trying year that's gonna come up, would have some ability to do that. And so I feel like there's a little bit of that would be a bait and switch on my unanimous vote a little bit. So I guess my point is that AOE Richardson is in charge now. He's in charge. I mean, or as of December 31st. And he's gonna have a new employee. We don't come in and meddle with the job descriptions of, Elizabeth or Kelly or anyone else. We just count on him to do it. And he's a strong person and he can do it. And he has authority to do it. And I don't want to get in the business of, with due respect, I don't want to get in I don't think y'all want me in the business of bringing AOE Richardson in here to question how he's doing, defining staff roles and whatnot.
Commissioner Davis, did you seek recognition?
No, I think we're on the right track here.
Okay. The right track of being what?
I'm waiting for what you about to say next.
All right. Well, I tell you what, do you want to amend the motion, or do you want me to give it a shot at it?
Why don't you get a shot?
Oh. Ms. Harrison's just cringing. No, somebody who knows how to talk.
Okay.
And I will make the motion. I will ask my motion be amended to authorize the hiring of Mr. Roberts at the conclusion of his term as administrator on a part-time basis to provide assistance from Mr. Richardson as Mr. Richardson feels necessary. And then also between now and January 7th, direct Mr. Richardson to come up with bullet points to reflect how this might operate, in what circumstances and that type of thing. And I think that's appropriate because you're right, we did do a personnel policy and it kind of outlines what everybody needs to do. So that would be my motion, and he would present that to the commission for consideration at our January 7 meeting. Because Ms. Ecke indicated that there's not going to be a problem with bringing him on part-time after his time as AOE has lapsed.
Well, I would only ask that you amend your motion, or we state it, so to say that he just comes up and on January 7th, he's gonna be the AOE sitting right here, and we instruct him to tell us the roles by bullet point or however fashion he wants to do it in his first AOE report, and explains it to us. I don't know if we need to approve it. Because I think that's the part I just don't want to open that can of worms, but.
Commissioner Dan Davis.
Since we kind of made that part of the motion, I think we could easily just say, I think we could probably put that verbally, that he's just gonna make that part of his AOE report on the 7th. I don't think you have to do any extras on that one, but
Right.
since you brought it up.
Yeah.
But we can just, and like I said, and to amend that on the 7th of January, he will give us those as part of the AOE report.
Yeah. I'm fine with that.
I don't understand what the problem is in us adopting what Mr. Richardson comes up with, because it's akin to the policy manual, personnel policy manual, in the sense that it details how they envision this relationship would proceed in the same way that the personnel manual deals with rank and file employees. So I
I'm not
just
gonna
don't-
die on that hill. That's fine if you want to do it that way. I just don't think you need to, but if you want to keep the motion that way, well, I'll vote for it. I mean, it's not.
Ms. Dooley, what are your thoughts on that motion? Would that give you any level of comfort knowing that we would be approving in January, going in and approve the situation, give them authority for this to happen now, knowing that on January 7th, we would approve the document reflecting how that would proceed, what that would look like? Would that give you a comfort level to vote on this in favor of my amended motion today?
In the amended motion, if I understand, is just
We're authorizing,
To,
the amended motion is to authorize, bring him on part-time as consultant, and then on January 7th, we would again adopt the nuts and bolts of what that would look like
Yes.
for Mr. Richardson.
Yeah, I think I'm fine with that.
Okay.
I mean, it's not like I trust or don't trust someone. I just did not like the way that was worded right here.
Well, that is my motion. As confusing as all that was, does everybody understand the motion?
I'll second it.
All right, the motion as amended. All those in favor indicate by saying aye.
Aye.
All opposed, no. The motion is approved. Administrator Roberts, your AOE report.
Your final one.
The final one, and I'll try and keep it brief. You know, I've
Well,
been
keep
here.
this brief, nothing else.
That's true. I will, describe, I know all of you have been to Disney World, and, if I tell you, that this has been kind of like, Mr. Toad's Wild Ride. It's been fun, but, there's been some challenges along the way. All of those challenges would have been impossible without the folks back here, the folks still back at the office. They're the best. You can feel confident, and John can feel confident going forward. They've got the bases covered. They will not let Davidson County down. So, just want to thank all of you for all the support and make sure they know exactly what they've meant to make me successful. So with that, I'll close out my tenure as AOE.
Very good. And we certainly appreciate the leadership you provided, but I do want to pick up on, in fact, I meant to say it earlier, pick up on, the staff and the staff that's back there, seeing how everyone pulled together and not only holds all these elections every time, but how you came together and under short notice, sped up the process by which we could certify the election today as just a testament to the quality of the staff that we've got. And having known Administrator Roberts for probably longer than either one of us want to recognize, I appreciate what he has done. And while we are excited about Mr. Richardson, you'll be missed, but probably just to a degree. So, but in any event, any other thoughts on this?
And we all share, I think we've shared our thoughts before, but we do thank you for your service and your continued service, and we appreciate all the great work you've done.
All right, and now for even more excitement, we've got registrations to review. So for those who are online, the next several minutes will be just us going through and fulfilling our statutory obligation to review a certain number of registrations over the last quarter to make sure there's no errors or such. And
Do that at the end.
yeah, it's on here. So yeah, so we'll do that.
While you're doing it.
Okay, we're back in session. Our duties to review the registration, a certain number of registration cards for the quarter has been completed. So the next item is our next scheduled meeting, which is January the 7th, 2026 at 3 o'clock here in this room. Administrator Roberts, anything you want to add to that?
Hope you enjoy your next meeting.
Very good. All right. Seeing no further business, I'll enter. Commissioner Byrd moves to adjourn. Is there a second?
Second.
Commissioner Dan Davis seconds. All in favor say aye.
Aye.
All opposed, no. It carries. We are done.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.